So there's a new law in Florida that will allow healthcare providers to deny providing healthcare services to people whenever they just feel it doesn't vibe with them personally. And it's more dangerous than I think even the people that wrote it realized. Let's talk about it. So on May 11th, 2023, the governor of Florida, Ron DeSantis, signed the Protections of Medical Conscience bill into law, and it will go into effect July 1st, 2023. The goal of the new law, per the people who wrote it, is to provide the right of medical conscience for healthcare providers and payors to ensure that they can care for patients in a manner consistent with their moral, ethical, and religious convictions. Further, it is the intent of the legislature that licensed healthcare providers and payors be free from threat of discrimination for providing conscience-based healthcare. What that all means is essentially the law would allow healthcare providers and insurance companies and employers in Florida to decide that they can just opt out of healthcare management that they don't feel morally aligned with, and they can't be retaliated against doing so in any way. And on its surface, before I really read the details, I didn't think that this sounded too wild, to be totally honest. I've worked in healthcare for a while, and I've seen situations like over and over where a person wasn't comfortable performing a certain treatment, so they referred that care to someone else who was trained and comfortable with providing it, and the patient received, in the end, the care that they needed. And nobody felt pressured into, providing care that they didn't want to provide or that they weren't trained to provide. So this concept on its face, it wasn't new to me. I was not shocked. Side note, this may be a topic for a different day, but do I always find it really weird when people do decide to work at a place that provides certain services that then they don't want to provide? I'm like, why are we doing this? Why are you here? You could go work somewhere else. But being able to opt out of services and providing certain services is actually a federally protected right for healthcare workers. So they are allowed to work there and then say, no, thank you. So I guess at the end of the day, it doesn't really matter if I think it's weird because it's already allowed. The conscience and religious non-discrimination statutes that are federal protect healthcare providers' conscience rights and prohibits discrimination against healthcare providers who refuse to participate in certain services based on moral objections or religious beliefs. Those statutes are they're explicit, they're defined, and they're largely surrounding things like pregnancy termination. But there's also statutes for things like immunization, disability services, and various general healthcare services that people can opt out of due to religious beliefs or moral convictions. And I will leave the link to that info page of what you can get an exemption for down below if you want to check it out. We won't go through all of them in this video. But basically, the existing federal law is saying, hey, nobody can force you to participate in providing healthcare services like a termination of a pregnancy against your will. You can't be forced to do it. And additionally, if your office doesn't provide certain services, you can still apply for federal grants and funding, basically removing some potential financial discrimination from going on because you don't provide those services. Those statutes as they exist now, they're pretty generic blanket statements, and it doesn't cause too much of a stir in healthcare really because most places will just refer you to someone who can help you out if they don't provide the service that you want, and it's not really a huge deal, right? So I initially thought this Florida law was just kind of going to be redundant, and it said the same basic things as the ones that already exist, and they just wanted their own because they're special. And I want to go back to that naive version of myself because the more I read the terms of service of this thing, the more sketchy it got very quickly. Now remember, we already have protections for conscience-based healthcare management that are federally out there, right? So this is already blanketing them, which then made me think, what else are you trying to get out of doing here, friends, that isn't already federally protected? So I started to read how they defined all of their terms, right? Because that would give a better idea of what exactly is protected and what isn't. We started with what is a conscience-based objection. What exactly can they opt out of, basically? A conscience-based objection was defined by the bill as an objection based on sincerely held religious, moral, or ethical belief when it comes to people providing actual healthcare. Which immediately feels very broad, right? Doesn't it? Because you can literally deny providing literally any care, saying it's against your religious, moral, or ethical belief, and there's no way to prove that you are not just being discriminatory or that you're making it up to prove a trending political point, because it's your own belief and no one can prove that's not what you actually believe. So this is already in contrast to the federal laws that spell out a bit more strictly what exactly you can and cannot opt out of. And here in this law, it seems like it's just kind of a free-for-all. But my past very hopeful self myself thought, will this leave holes, huge holes that will allow people to exploit the heck out of this system? Yes. Will people be denied care because their healthcare providers are discriminating against them? Absolutely. But just because they don't want to provide certain treatments doesn't mean people won't get care. They'll just refer them to other people who can actually provide the care, and it's going to be slower, but it's going to be like relatively okay. Right? Can we tell that I've been working on catastrophizing less in therapy? Good. So we have healthcare providers that can literally object to anything, saying it doesn't vibe with them. And let's look at what a conscience-based objection for employers and insurance companies looks like, shall we? For insurance payors, aka employers and insurance companies, they can also decide that they are morally, religiously, or ethically against anything as well. But they have to back it up with some kind of documentation. They have to show that in one of the following, either their company's governing documents, published ethical, moral, or religious guidelines, mission statements, constitution, bylaws, policies, regulations, or articles of incorporation, they have to prove that one of those published things back up their claim that whatever it is they're trying to not do, that it's against their stance and they therefore don't have to pay for that service, which again is very, very broad and seriously like the worst fact-checking method ever, right? Like it's so easy for you to just go onto your website and change your company's mission statement at any moment's notice because you no longer want to cover a certain treatment. You can just like make those things magically align. But that is apparently all the proof that they are going to require. And that makes me feel gross inside because I don't want what medical care is covered by my insurance to have to be determined by a CEO or insurance company's ethical whims, right? That seems sketchy. I want what care I can get to be based on like science and research and up-to-date guidelines by people in the profession. But apparently that is wanting too much. Honestly, insurance not having to cover things made me way more worried than providers not having to cover things, since you can find a new healthcare provider, but literally anything can be denied by your insurance company because they don't feel like it. So even if you switch providers, you still can't get it paid for. That's not ideal. But it's not all that's not ideal. It gets worse. They went ahead and defined healthcare services for us, right? To let us know exactly what they mean when they say a provider can deny healthcare services. And when they say healthcare services, they are referring to standard medical care, procedures, surgeries, diagnostic testing, psychological therapy, counseling, and all of those things. I thought that's kind of what I expected, right? That's what I also think of when I think healthcare services is that list above. And it does basically give a total opt-out option for providing care that you personally don't align with, which makes sense for the bill, right? But healthcare services also includes dispensing or administration of any drug, which made me think, okay, so like nursing staff can just like not give meds because they don't agree with them. Like what if they're the only people available there at like a long-term care facility or something to provide the ordered treatment, but they just don't like agree with it? Like, what do we do there? Does this also mean that like pharmacists just don't have to dispense medicines that they feel like are not needed or they don't agree with? Like where does this line get drawn? It seems like a giant area that could be exploited, right? But even this was not the part that gave me the most pause from this bill. They specifically mention referrals being a healthcare service, which might not seem like a huge deal, but to me, with like my primary care background and looking at this from a primary care angle, this is probably the most dangerous phrase, clause, whatever, in the whole bill. As I mentioned before, normally when you don't feel comfortable providing medical care, whether it's because you don't feel comfortable ethically with the procedure or you don't feel adequately trained and would like someone else to provide those services, or the patient simply just like requires a specialty level of care, you refer them to another provider who can provide those services. You help the patient find those people because the system, it's chaos and help is always great. Referrals are very basic coordination of care in our system that are absolutely necessary and ensure people get the care that they need and they want. And they're required for many people to receive care. It's not something you can just like work around depending on your type of insurance. If you have an HMO or Medicare or Medicaid or any managed care, you need a referral to go to a healthcare provider that is not your primary care or gynecologic provider. It's like a hall pass, right? You have to have that in order to be able to go to any specialist. So if your primary care person refuses to send those referrals, that leaves you as a patient really trapped. They can't get the care that they need from their own healthcare provider, but they also can't like they can be denied a referral to go see a different healthcare provider who could help them get the care that they very much need and deserve, which then means they need to exit that primary care office entirely, find a new primary care office that is accepting patients, wait the 6 to 12 month wait that most offices have to get in and establish care, make sure that that person is comfortable providing the referral, get a referral, and then wait for that specialty visit. To not provide a referral, in my opinion, is medical neglect. You, as a healthcare provider, you don't have to provide services, right? Nobody should force you to do anything, but you can't pretend like those options aren't even on the menu. And I use this analogy all the time, probably because I worked at Chili's for like 8 million years. But as healthcare providers, we're like servers at a restaurant. It's our job to know all the different options that are available to you and to explain them well, and to even make recommendations based on you and your preferences and what you like and what we know is good and what might be a good fit, right? But ultimately, you as the patient deserve to choose what you want. It's your choice. Just because I don't like something that is on the menu doesn't mean you can't order it. Even if I refuse to serve it to you, I should go find someone else who can. Telling people that they can opt out of referrals is like giving them permission to just omit fish that's on the menu and not allow patients to order it, even though it is very much still an option. It's just being blocked because that particular healthcare provider has a moral objection to it that the patient might not have. The patient doesn't have the same morals as the provider, right? People deserve to have the freedom of making their own informed medical choices and not to be restricted by people with power in the situation. And it's not just providers who can block care with this law, because the bill also defines what participate means, as in who does opting out of participating in care, who does that even mean? Participation is defined as taking part in any way of providing or facilitating any healthcare service or any part of a service. So as a care manager, they don't need to help facilitate communication between a patient and their care team if they don't agree with the diagnosis and treatment. An MA at the office doesn't need to put in a referral through the system if they don't agree with the service being referred for. Literally anyone involved in any coordination of care can opt out in Florida because of this bill. And there are a lot of people involved in healthcare, friends. That is a lot of places for the healthcare machine that is already really struggling to work for it to break down. Are you ready to have a breakdown hearing about all of this? Yeah, me too. Wait just one moment though, because we're not done yet. We haven't even touched on the whistleblower protections and the immunity clauses. So one of the first things I don't love about all the protections clauses that are in here is it states that individuals who opt out of providing any kind of care based on conscience objections, they can't be discriminated against in any way from the medical community or in their workforce. So as an example of how this might not play out awesome is what if we have in the case before where someone doesn't want to provide a referral or they don't want to coordinate care, they can't be fired for it, right? So you can't say oh, well, this is part of your job, you have to put the referrals through. No, if they're saying, hey, this is based on a conscious decision for ethical, religious, or personal beliefs, nothing can happen to them, right? Because it's protected. Another example of how this might play out would be let's say you have a large scale medical institution that's an academic medical center, supposed to be all up in the research, right? And you might have someone who's vying for a leadership position who's constantly avoiding following evidence-based care practices due to a conscience objection. But they can come back and sue saying, it's not fair. I should still be allowed to lead this organization. You can't discriminate against me just because I don't do those things. And then we have more and more medical directors who care less and less about science and more and more about the feeling of all of this type of thing and what they feel their morals and ethics are. And then we're running into this really weird thing where it's well, these are my morals. And it's but those aren't everybody's morals. We're supposed to be science-based, not feelings-based. And what is happening? And I just don't know how they didn't see that this would be problematic. They might have known it was going to be problematic and they probably just did it anyway. Other things that kind of fall under the whistleblower and protections is when people suffer, when conditions get worse, when people are harmed by the lack of action or healthcare coordination because of this law, the patients can't sue. Because the law provides protection from civil lawsuits that may occur. Normally you can sue if care was not provided and harm was caused. But here you can't sue because they have the right to abandon you in a healthcare system to go and figure it out for yourself if they just don't agree with you or the care that you would like to receive. So kind of in summary of what all the whistleblower and protections are, is it just states that individuals who are providing any kind of service based on any conscience objection, They can't be discriminated against in any way in the medical community or in the workforce. So basically the vibe is kind of just like, hey, go out, do whatever you want. You're not going to get in trouble. Here's like your free pass. Enjoy. Consequences, what are those? And I kind of see that as a recipe for disaster, but what do I know? I have this whole bill, soon to be law, linked down below if you want to see what other terms are defined as and exactly like what all these rules look like when they're laid out. But that was the gist. Are there limitations to the law? Yes. Thank goodness. There are a few. Let's go over them. This law cannot be used to avoid giving care to someone based on patient race, skin color, religion, sex, or national origin. Or at least they cannot explicitly say, I am denying you care based on those things. And I'm sure that they would never, ever create like weird workarounds or phrase things in a different way to still discriminate based on those things. No, never, never. Also, note that like sexual orientation, age, gender, identity, and disability, amongst other things, those things were not on the list that are protected against. So your healthcare provider can still explicitly deny care based on those things. They can just come right out and say it now. So that's lovely. Also lovely, insurance companies may not decline to pay for things that they are contractually obligated to provide for that year, such as annual physicals, certain cancer screenings like pap smears, mammograms, colonoscopies, etc. So they are at least held, the insurance companies, to the legal minimum of their contractual obligations. So hooray, they can't go back on those. And this next one just like boggles the mind as to why it needed to exist in the first place. The new law cannot be used to get out of providing care in emergency situations according to state law. So I guess like if you normally deny care to lesbians, but one is dying in front of you, you can't just let them die in an emergency if you are the only one around. So why did we need a law to spell out that entire situation? That's a little bit frightening to me, but here we are. I'm glad they added that as a clarification. So to wrap up, like what are the real implications of this, right? I know they went into this bill thinking that they were giving people an out when it came to providing pregnancy termination and gender affirming care, right? Because those are the things that they're being told to hate at the moment, right? But I think that this could have effects that are much farther than what they imagined, because there is so much discrimination in the healthcare field. It's just steeped in it. And this is opening the door for all those people to just like go crazy. When I worked as a primary care provider, I encountered countless patients who had been denied all sorts, a whole range of care because providers didn't agree with it. Things like STI screening, birth control, psychiatric medication, therapy, weight loss medications, PrEP, pain management, treatment for addiction. The list could like literally go on. And I would have providers explain to my face that patients were just like too morally loose. They were too lazy, or they just needed to like buck up. I've had people say like straight up, like, I just don't believe in that diagnosis. And therefore they would not prescribe or treat or diagnose these things or work with patients on it. There was not one day that I didn't meet someone, a patient in my office, who came in saying that they had been denied basic treatments like the one I just mentioned because the other provider just like didn't believe in it, or they just didn't listen to them and they blew it off. So the patient left and didn't get medical care. I have experienced this myself. I'm sure many of you have as well. Healthcare is filled with a lot of really great people, a lot of great providers that really, really care about their patients, right? But it's also filled with a lot of providers who provide wildly subpar care based on their own preconceived notions and biases. And they used to have to at least pretend on paper that they were being fair or sending them to someone who could be fair. And the thing I hate about this is it just like removes that, right? They can literally just deny care and wash their hands of it. No further coordination of care needed for any treatment or therapy that they don't personally agree with. Now that we've kind of laid the foundation, let's try to leave you not totally in a lurch, okay? What can you do about this? If you live in Florida, I really think you should go and have a frank discussion with your healthcare provider, particularly your primary care provider. Is there anything that they would not feel comfortable prescribing or managing for you? Just ask. Do you have an inkling that they may deny care based on their own conscience? Have they ever like blown you off before or made you feel like you aren't heard at appointments? Anything like that's going to ring an alarm bell that like this might happen. Go find a new primary care person now, okay? Ask friends who they like. Go on like a Facebook group in your area. People have a lot to say on Facebook. They will rant for a long time about you. Do not Google yourself in a Facebook group, my friends. It's bad for your mental health. But also, like, you can find some really legit providers through there. So go and switch to a provider who is decent. Switch to someone who will have your back, right? And do it before you run into an actual issue so that there's less of a time crunch in this whole thing. And actually, this is just like really good advice in general. Find a primary care provider who will listen to you and who respects you and offers and explains the entire menu to you, okay? So that you can make informed choices about what you are going to order off of the healthcare menu, because that is your right and you deserve it. And if you don't live in Florida, watch for these types of laws in your state, right? Because if you know if they're passing it here, other states are probably going to try to as well. And if your state is trying to pass something like this, let your legislators know why passing such broad laws is harmful and will have more consequences than they are likely anticipating. And this will harm patients. And if you are a healthcare provider who can see yourself using the benefit of this law, please refer people out to the services they need. Don't abandon people to try to figure out our really backward systems by themselves when they are in need of care. You don't have to provide it yourself, obviously, but please just help coordinate that to make the process smoother. And if you are now a puddle of sadness and you need a slightly more humorous topic, you'll probably find this video on Starbucks' latest laxative that they're marketing and why it is making such a splash in the coffee industry and toilet industry. You might find it interesting. So thanks for hanging out today. And I do hope you always remember, my friends, that you are not alone. You are more than enough and you can do hard things. I'll see you next time. Bye.